Here.
It's anywhere. Oh, there you are. Okay.
Madam Court Reporter, are you ready?
Let me just, yes, I am ready.
Okay, let's go ahead and get started. December 18th, 9:02 a.m. And let's start with a roll call, please. Pam?
Yes, good morning. We'll begin the roll call with Member Bitzer. Present.
Here.
Member Cates.
Here.
Member Duval.
Present.
Hearing Officer Garcia.
Here.
Lena.
Here.
Member Trujillo Davis. Member Trujillo Davis, are you present? I think I see you on there.
Oh, there she is.
I'm sorry, was that Member Trujillo Davis?
Yes, can you hear me now?
I can hear you now, thank you. Chair Volkerding?
Present.
Hearing Officer Garcia, you have a quorum.
Thank you very much.
Madam Chair, if I
Yes.
might, I guess it's the appropriate time for me to recuse myself from the subject matter in question. I have been advised by counsel that I have a conflict.
Okay, Member Bitzer, it's my understanding you can attend the hearing, just will not be involved in voting or deliberation.
Okay.
Thank you. All right, this hearing will please come to order. The time is 9:04. My name is Karen Garcia. I have been designated by the board to serve as hearing officer, and I will be advised by the board's counsel from the Office of Attorney General, Carla Sororia. And we just did a roll call, so we have a quorum. I don't think we were going to keep that. This is a hearing in EIB 20-55R to consider the proposed amendment to 11.5.1.16 NMAC, record keeping and reporting occupational injuries, illnesses, and fatalities. Today is December 18th, 2020. Due to the COVID-19 public health emergency declared by the governor and following guidelines for public gatherings set out by the Department of Health, this hearing is being held online via the WebEx platform. 20.1.1.306 NMAC does allow for participation via conference, telephone, or other similar device, given all participants are able to hear. If at any point during the hearing, technical difficulties arise, please bring them to my attention and efforts will be made to remedy the situation. The petitioner in this matter is the New Mexico Environment Department Occupational Health and Safety Bureau. No other person has filed a notice of intent to present technical testimony. There will be designated time for any member of the general public to present non-technical testimony. The Environmental Improvement Board has authority to amend the Occupational Health and Safety Regulations pursuant to NMSA 1978, Section 50-9-12 of the Occupational Health and Safety Act. This hearing will be conducted in accordance with the Open Meetings Act, the State Rules Act, the Occupational Health and Safety Act, and the board's rulemaking procedures. This hearing is being reported by Cheryl Arreguin from Albuquerque Court Reporting Services. Parties interested in a copy of the transcript may contact the court directly at the conclusion of the hearing. Copies of the proposed changes have been available on the board's website and at the board's office as to interested parties upon request. The hearing will be conducted in a fair, impartial manner to assure that the relevant facts are fully elicited and to provide a reasonable opportunity for all persons to be heard without making the hearing unreasonably lengthy or burdening the record with unnecessary repetition. The rules of civil procedure and evidence shall not apply to this hearing. As hearing officer, I will make such orders as may be necessary to preserve decorum and to protect the orderly hearing process. To that end, I will ask all persons at this hearing to please silence your cell phones. During the hearing, please be sure to mute yourself until you wish to speak to help minimize background noise. The hearing shall proceed as follows. Board staff will present pre-filed exhibits. Exhibits admitted into evidence are available for review by the public. All testimony will be taken under oath. As hearing officer, I will rule on any objections to evidence and will admit any relevant evidence unless I determine that the evidence is incompetent or unduly repetitious. Any person offering an exhibit shall provide an original to the board administrator and a copy to each of the board members and to its legal counsel, and shall also provide additional copies for persons attending the hearing. If visual aids are used, legible copies must be submitted for inclusion in the record. Please know that the board will not make copies of any exhibits used at this hearing. Any person who wishes to make a brief opening statement before presentation of his or her direct testimony may do so. Petitioner will present its direct testimony on the proposed rule changes. If any other persons, including members of the public, wish to present non-technical testimony about the proposed rule changes, they will testify as called upon. If you are a member of the public, please email the board's administrator at pamela.jones@state.nm.us to notify us that you intend to present non-technical testimony and include any exhibits being offered. Because this hearing is being transcribed, please remember that only one person may speak at any one time. Please direct your testimony and answers to questions to board members, and please speak slowly and clearly so that the court reporter can get down all of your testimony. Any person who testifies is subject to cross-examination on the subject matter of his or her testimony and on matters affecting his or her credibility. Petitioner has the option of presenting its witness. The petitioner has the option of presenting its witness as a panel for purposes of cross-examination. Cross-examination by the board members and the hearing officer will be conducted at the conclusion of each presentation, followed by cross-examination by the public. Please remember to direct all testimony and answers to questions to the board itself, even if someone other than a board member has asked a witness a question. Any person attending the hearing is entitled to conduct whatever cross-examination is required for a full and true disclosure of matters at issue in the hearing. As hearing officer, I may limit cross-examination to avoid harassment, intimidation, needless expenditure of time, or undue repetition. At the petitioner's discretion, and if time permits, rebuttal testimony may be given at the conclusion of the public testimony in the same order as direct testimony. Any person who wishes to make a brief closing argument may do so at the conclusion of the hearing in the same order as the direct testimony. Okay, before we proceed with the first petitioner, I'd like to address a procedural issue that has arisen. A member of the public has sent in a comment that they feel that the hearing was not noticed properly. So we need to address that as the board. We need to address that because that has a bearing on whether we continue the hearing or not. So, Pam, I believe that was comment number 1 by a Mr. Chris Metchels. And I understand the department has seen this comment as well. The comment stating that the hearing was not noticed properly. So if I could ask the department to please go ahead and address that, either the petitioner or the department counsel, if you would please address that issue that has come up.
Joshua Spencer for the department. I want to make sure that everyone can hear me. Yes, okay. I would like to know, I've not seen the comment from Mr. Michaels. So if you could direct me to what his specific issue is regarding notice, I would love to address that.
Okay. In the public comments, it was comment number 1, and I'll go ahead and read it. This comment deals with improper notice of this hearing. The Sunshine Portal notice has the cutoff for comments as 11/27/2020. He says, I very nearly did not comment as I was after that date. However, I decided to check the newspaper notice, and it has comments until the hearing date. He says this error seems unrecoverable and suggests the hearing be rescheduled.
Okay, thank you very much. I have received the email, an email regarding this issue, but I did not see the public comment. My apologies, Hearing Officer Garcia. So the simple fact is the deadline that Mr. Michaels is referring to in the Sunshine Portal is contained in the exact same public notice, word for word, verbatim, of every other place that we gave notice. That means in the New Mexico Record, in the Albuquerque Journal, on our own website, on EIB's website rather, as well as the Sunshine Portal. So there's no distinction whatsoever between any one of the public notices. So the public notice that Mr. Michaels is referring to on the Sunshine Portal is the exact same as the ones that are published everywhere else. In the notice, the public hearing notice, there is a deadline of 11/27/2020, but that deadline is specifically for and only for is issuing notices to notice of intent to present technical testimony. Nothing else. There is no comment deadline. The comment deadline goes through today, and that's actually stated in the notice. And I will pull that up so I can speak directly to the notice and read from the notice. And that is Exhibit 5 that was previously offered to the board. Is that the hearing, and where I'm on in the first page, let me find the November deadline date. And that's on the second page. It says notices of intent for the hearing must be received by EOB from 5 p.m. by 5 p.m. on November 27, 2020, and should reference the name of the regulation, the date of the hearing, and the docket number. That's the only mention of November in our notice whatsoever. So Mr. Michaels has come to a false conclusion. There is no deadline for commenting. Comments are, of course, allowed even through our hearing today, and that's brought up in the first page of our notice as well, is that public comments will be offered through email as of today's date as well, which the chair, Hearing Officer Garcia, already mentioned.
Okay, thank you, Mr. Spencer. Do any of the board members have any questions about this for the department or wish to discuss this particular issue?
I was curious, does the board counsel have an opinion?
I don't really have anything to add to department's counsel, but I would like to have it on the record. When was the notice published? I want the board to have a sense of how long the comment period was open to the public up to today.
Absolutely. For the board, we have an affidavit of publication, that's Exhibit 6. This is the affidavit of publication within the Albuquerque Journal for 3 consecutive days from from October 16th, the 17th, and the 18th. And we also have the affidavit of publication that the New Mexico Register, Volume 31, that it was published in that volume, which I believe was dated October 15th, if I'm not mistaken. I can double check that if there's any question. It has been on the website, EIB's website. We have that information here. It was posted on the EIB's website on October 15th, 2020. The link is available in the Statement of Reasons. That's in Exhibit 10. There's also the posting to the New Mexico Sunshine Portal, also on October 16th, 2020. And I said 2010 for October 15th, 2020. I think I said 2010, but it's been on that EIB's website since October 15th, 2020. So the information's been out and available since the middle of October. There are 60 days as required under the statute. And one more, am I getting really bad feedback? Is that me? Okay, I think much better. Okay, that's not working. Is anyone else hearing some feedback?
Yes.
Okay. All right, let me try this.
Cannot hear you now. Cannot hear you.
Members, can you hear me? Okay.
I'm sorry, who said that?
This was, apologies, this is Council Carlos Loria for the board. While Council Spencer addresses his audio issues, there was a question from the board about my general thoughts on the matter. It's my position that the notice was published in accordance with the board's rules.
Can you hear me now, please?
Yes.
Oh, fantastic. I am so sorry. Of course, we're going to have difficulties. My apologies to the board. Could the reporter tell me where we last were when we heard?
Let me look. The information has been out and available since the middle of October. There are 60 days as required under the statute. And one more, and we cut out.
Okay. And one more point I wanted to bring out from the actual notice itself. At the very first paragraph reads, the Environmental Improvement Board will hold a public hearing December 18th, 2020, beginning at 9 a.m. via internet. I'm cutting out some of the parentheticals. Via telephone, and comments will also be received via email through the conclusion of the hearing. So there is no deadline for comment up to and including the end of the hearing today.
Ms. Garcia, you're on mute.
Thank you. Thank you, Mr. Spencer. You may not have heard our counsel, Carla Soloria, say that her conclusion was that the department appears to have met the requirements of the rule and the law. Okay, does anyone have any questions? Any board members have any questions about this issue? Anyone see any reason why we shouldn't move forward with the hearing then? All right, so we will proceed. Does the board staff have any exhibits to introduce as evidence? Board Administrator Pam?
Yes. Can you hear me?
Yes.
Okay. Madam Chair, I have the following exhibits. I have the petition to amend 11.5.1.16 NMAC of Occupational Health and Safety Regulations and request for hearing. I have notice of hearing determination and hearing officer appointment. I have notice of intent to present technical testimony. And I have the petitioner's initial exhibit list. Madam Chair, that's all of the exhibits received.
Okay. And so does that come to 12? I lost count. Is that 10 exhibits? I just want to make sure. Go ahead.
There are 10 exhibits listed on the petitioner's initial exhibit list.
Okay, so exhibit 1 through 10 are now included in the hearing record.
If I may interject, the previous pleadings are exhibits as well. So I believe it's 4 because the 10 that Pam just listed are subset to that 4th exhibit. Pam, is that correct?
That's correct.
Okay, so that would be exhibit 1 through 4 then? Okay, exhibit 1 through 4 is now admitted into the record. All right, we will begin with the technical testimony by the petitioner. The department has identified Robert Genoway as its technical witness. So Robert, if you could please raise your right hand, the court reporter will administer the oath.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right, the petitioner may now present direct testimony on the proposed rule changes.
If I may, Hearing Officer Garcia, I'd like to start with an opening statement.
Yes, sir. You may begin with an opening statement if you wish.
Thank you. In for the record too, we're here, of course, Mr. Genoway is our witness today, and I'm also representing the board here today is Miss Mia Napa. Okay, I knew I was going to sit up. Napolitano, Assistant General Counsel for the board as well. She's present as well. She is co-counsel in this matter, and she is here and available for questions as well. As the board has been aware, we're here pursuant to the 2020 petition to section 11.5.1.6 of the code. And we're requesting that the board amend this for 4 reasons. It first fulfills the purpose of the Occupational Health and Safety Act. Second, it's in line with the mandates that are required underneath OSHA is how I'm going to refer to the Occupational Safety Act, for brevity. Regulation of employers' reports and record is not a novel concept or a new development. It's been in effect for decades. And because of COVID-19, this amendment is absolutely required because it's a response to the COVID-19 health pandemic, and it is necessary for the department to have. Now, my first point was that it fulfills the purpose of the Occupational Health and Safety Act. So the purpose, as described in the Act itself, is to ensure that every employee has a safe and helpful work condition. And underneath the underlying purpose, it states that on subsection A of 50-9.2, it says that the establishment of the Occupational Health and Safety Regulations applicable to places of employment state that the OSA provides specifically for regulations to be.
Excuse me, Mr. Spencer.
Yes.
Are cutting out a bit. I'm not sure what's happening.
Okay.
Maybe if you could speak slower for me.
I will certainly try. Okay. So according to section 50-9-2, subparagraph A, the OSA Act provides for specifically the establishment of regulations to regulate places of employment. And that's what we're doing here today. And I really want to direct the board's attention to subparagraph D, which says that OSHA can assure a safe and helpful work conditions for employees by providing for appropriate job-related accident and illness that will help achieve the objectives of the Act. So the OSA itself specifically directs, one, to enact regulations, and then two, to enact regulations regarding job-related accident and illness reporting procedures. And that's what we're modifying today. Now, my second point for adoption of the amendment is that is in line with the mandates of OSHA requiring accident reports and records. So not only do we have that subparagraph D in 50-9-2, there's an entire section, that's section 50-9-19, that says, subparagraph A, that every employer shall keep records and submit reports of occupational injuries and illnesses as prescribed by the department. So it's directly in line that OSA has mandated that the reporting of accidents, injuries, illnesses is required by the Act. The third point is this is not a novel concept, the regulation of reports and records. The section we're seeking to amend is entitled Record Keeping and Reporting Occupational Injuries, Illness, and Fatalities, was first codified in 1975. And since 1975, it's been in 9 separate iterations that through 2015, as well as 2 emergency amendments in 2020, one of August 5th and the other December 3rd. This isn't a novel concept. This code has been in effect since 1975. In 9 different times it's been tweaked or moved, but it's been there. The records and reporting requirements have been and continue to be an integral part to the OSA Act and part of NMED's ability to enforce the Act and to work. And the fourth reason we're asking for the board to adopt the amendment is essentially because of COVID-19, this response is required. The department needs to have effective and timely notice of an outbreak or a positive report or positive COVID-19 person in the workplace. This is a public health emergency, and there's an executive order from March, Executive Order number 2020-04, that calls this a public health emergency. COVID-19, as we all know, presents a severe danger to the public, and specifically in what we're asking about here is workplace safety. there's an urgent need to adopt this rule to ensure the safety of a workplace. We know how easily COVID-19 is transmittable from person to person. The requirements are within 6 feet for 3 minutes, and that is a close contact sufficient enough to mandate quarantine underneath the public health orders. And the departments having immediate knowledge of this a positive test is useful for the Bureau in order to allocate its resources to help limit the transmission and otherwise respond effectively to COVID-19. Our current emergency amendment is due to expire on April 2nd, 2021. This amendment would be a permanent change, and it would be a permanent change specifically relating to this novel coronavirus and the reporting underneath the proposed amended code. With that being said, I would like to call my first witness, who has already been sworn, Robert Genoway.
Okay, Robert Genoway, go right ahead with your direct testimony.
And I would like to understand how the board would like me to refer to the exhibits. Would we like to?
Mr. Spencer, you're cutting out. We didn't hear the last part of that sentence.
You're on mute now.
So the exhibits that I'm going to speak of are part of exhibit number 4, and I have them numbered there. Is that going to be sufficient for the record in order to make an identification? Should I refer to them as exhibit 4-1? Would that be sufficient to make sure that we can stay on track?
I think that's appropriate, Counsel.
Okay, that's what we'll. And if there's any confusion, please let me know. All right, Mr. Genoway, can you hear me?
I can, Mr. Spencer, thank you.
And then can the board hear him as well? All right.
Yes.
Mr. Genoway is the Occupational Health and Safety Bureau Chief, and I would like for you, sir, to introduce yourself to the board.
Thank you. Good morning, Hearing Officer Garcia, Chair and members of the board. I appreciate the opportunity to present this proposed amendment for your consideration today. My name is Robert Genoway, and I am the Chief of the state's Occupational Health and Safety Bureau of the New Mexico Environment Department, also known as New Mexico OSHA, or the OSHA Bureau. I have worked for the Bureau for 20 years and held a number of different positions within the Bureau, including compliance officer, consultant. I've managed both our consultation section and compliance sections, and have been the Bureau Chief since 2012. If it pleases the board, I would be happy to, although my presented technical testimony does provide an overview of the Bureau and its operations, since this is the first time that I will have presented to this board, I would be happy to provide more of an overview to the board if it would please the board for me to do so.
Does anyone want any more detail about the overview of the Bureau? We can go ahead and read your testimony, so you can go ahead with your statement.
Very well, thank you. The Occupational Health and Safety Bureau is presenting this amendment to 11.5.1.16 NMAC today for the purpose of protecting employees in the workplace statewide from the novel coronavirus and the resulting disease coronavirus disease 19, also known as COVID-19. In March of this year, when the pandemic hit New Mexico and Governor Lujan Grisham issued executive order, and subsequent to that, the New Mexico Department of Health issuing public health orders requiring certain controls for COVID-19 within the public and also within workplaces. The state's OSHA Bureau simultaneously developed and issued emphasis programs to provide for outreach assistance and enforcement of the Occupational Health and Safety Act to ensure COVID-19 safety in workplaces. From March through May, the Bureau handled many complaints regarding occupational exposures to COVID-19 in the workplace. And under the what's called the General Duty Clause of the New Mexico Occupational Health and Safety Act, the Bureau conducted investigations of those complaints, also investigations of workplace fatalities involving COVID-19. And for that first 2-month period, the Bureau also received reports of positive cases of employees. Although it's difficult to determine where an employee or any member of the public contracted COVID-19, the incidence of a positive case of COVID-19 among employees does represent a hazard to employees at that workplace as a result of potential transmission. And in early May of 2020, one of the first outbreaks of COVID-19 within a workplace was responded to by the Bureau and by the Department of Health. And at that time, in early May, both departments determined that it would be beneficial to develop a system to rapidly respond to positive cases of COVID-19 in the workplace. That collaboration resulted by the end of May in a procedure where Department of Health and the Environment Department shared information regarding positive cases that were reported through COVID-19 testing, both from Department of Health and from private providers, reported to the Department of Health, and then eventually reported to the Environment Department for follow-up with employers to ensure that certain control mechanisms were put in place to protect employees. These control mechanisms would include quickly identifying the positive case and ensuring that that positive case is isolated from the workplace in accordance with guidelines and directives from the state's Department of Health, and to quickly identify close contacts, as Mr. Spencer had defined earlier, to make sure that those close contacts are quarantined and would not present the potential for additional spread and potential outbreaks of the virus within that workplace. To ensure that areas of the workplace that were potentially contaminated from that positive case were isolated and disinfected to prevent spread, and that what are called COVID safe practices, and these are a set of controls, if you will, to ensure that the workplace is screening employees for potential symptoms of COVID-19, for regularly sanitizing the workplace, frequently touched surfaces to prevent transmission of the disease, and providing for other controls to help prevent spread. So by the end of May, the Department of Health and the Department of Environment began that process to receive information on positive cases and to assign those cases to staff within each agency to follow up with employers for each positive case. Over the next month or two, into June and into July, after receiving hundreds of reports of positive cases within workplaces, it became apparent to the Environment Department and our staff working on these rapid response cases that the time frame between a testing facility notifying the Department of Health of a positive case and the Department of Health then providing that information to our OSHA program within the Environment Department, that we were losing a number of days of potential control over the spread of the virus in the workplace. In other words, employers in many cases were learning of a positive case directly from their employees, and the Environment Department was not learning of that same case until, in some cases, many days, up to a week later. That was, in many ways, hampering our ability to quickly respond and ensure that those controls that I just mentioned were in place to prevent spread. And so the department developed an emergency temporary rule that would require employers to report under an amendment to the existing occupational illness and injury reporting rule that we're here today to request amendment for, to require that employers quickly report positive cases among employees once the employer has been notified of that positive case. And so on August 5th, the Environment Department Secretary issued the temporary rule requiring that employers report cases within a 4-hour period. Shortly following issuance of that temporary rule, the time frame from an employer being notified of a case to the department's ability to initiate a rapid response with an employer was decreased dramatically. Prior to the temporary rule, the average time frame from an employer's notification of a positive case to the department's initiation of a rapid response was just over 3 days, approximately 3.1 days. Within approximately 1 month of the new rule becoming a temporary rule becoming effective, that time frame was dropped to 1.8 days, and then into early October dropped further to 1.5 days, eventually reaching a low point of 1.2 days. So the time frame to initiate a response was drastically reduced as a result of that temporary rule. And so what we are requesting today is that the board consider making that rule permanent so that the department can continue to quickly respond and work with employers to ensure a safe workplace and prevent COVID-19 spread.
Thank you, Mr. Genoway. Does the board have any questions for the petitioner? Yes, Member Sweeney.
Good morning, Madam Hearing Officer Garcia and members of the board and the New Mexico Environmental Department staff and representatives, legal counsels. I just had some, I guess, questions regarding the NMAC's information about how this rule will fit with the ongoing like testing challenges regarding getting tested and getting the results back in a timely and efficient manner. And also the reporting challenges when, you know, who gets the tests and test results. Thank you.
Yes, and thank you for the question. And the timeframes for receiving testing results have varied, certainly varied through the course of the pandemic, based on, I think, a number of factors. I certainly can't speak for the Department of Health regarding delays that may occur in that process. I think that there have been times when the reporting was in a very short time frame, not more than 1 day, but there have certainly been cases that I've seen where that reporting, especially through private providers, can take some time, up to a week in some cases that I've seen. We have worked, the Environment Department has worked with the Department of Health throughout the period of the pandemic to prioritize testing among certain groups. Department of Health has been able to prioritize testing results especially for certain high-risk groups, including employees within those settings, such as congregate care settings, nursing homes, correctional facilities, and those types of establishments. So there is an ability to prioritize testing and results of testing, but delays in reporting of results of testing certainly does have an effect, and that effect has varied through the time of the pandemic as various influences have come up, and that's the best answer I can give to that. I know that the agencies are working hard to try and get those testing results back quickly.
Thank you, Madam Chair. I have a couple of other questions. May I proceed? I mean,
Yes, yes.
So given that with the testing and the challenge and receiving results, and I'll just be transparent here. I've had you know, with our family members and with people that I know, challenges in terms of the efficiency of getting reported results back and who gets those results and how efficiently those results are gotten, up to I think up to 14 to 20 days, unfortunately. And so that was the result. That was the premise of that question. And how does that, like I said, fit in with being efficient in terms of the intent to take care of the public health of our workers here in the state of New Mexico? So with that said, I think one of the concern, or one of the questions I had, is how again, back to the requirements on the reporting data, and if the employers would be on the, you know, responsible if there were those delays, not knowing, you know, not knowing when those test results come back, because it doesn't come to the employer, it comes to the individuals. And so how would that mechanism work if the individual does, therefore the individual, the employee, are they going to be then required to notify the employer, and then the employer then notify the NMAC? Thank you.
Thank you for the question. And my understanding is that the Department of Health's contact tracing program, when notifying an employee of a positive case, does advise that employee advise the employer of the positive case. I've come across rare situations where an employer was not informed by the employee of a positive case. However, there have been some instances. The department is notified through Department of Health and contact tracing of positive cases among employees. And so even in cases where an employee hasn't, for whatever reason, notified their employer, Our department does receive notification of those positive cases through the Department of Health and initiate a rapid response without regard to the employer's lack of knowledge of that positive case. So in other words, there have been some cases where our rapid response specialists within the Environment Department have contacted an employer to initiate a rapid response, and the employer was not aware of the positive case. Another, I think, mitigating factor to some of the delays in reporting is that when a positive case is identified and a rapid response is initiated, that the next step of the rapid response process, after making sure that that employee is isolated, is to identify close contacts and ensure that those close contacts are quarantined for a period of 14 days, so that when those close contacts are tested, any delays in testing results can be at least partially mitigated by that quarantine period.
Thank you, Madam Hearing Officer and Mr. Genoy. I have a follow-up question. So how does this rule, proposed rule, work with or fit logistically or even regulatorily and legally with the public order, health order mechanisms and process? Or does it not?
Thank you for the question. Yes, it does. And this is not something new with Department of Health's public health orders. The OSHA statute and the state's Occupational Health and Safety Act contain what I mentioned earlier is what's called a general duty clause, and this is section 5A of the state act, that requires that employers maintain a workplace free from recognized hazards likely to cause serious physical harm or death to employees. Under that general provision, recognized hazards within a workplace or within an industry or generally amongst the workforce become a recognizable hazard that an employer must control. For years, recommendations produced federally by the Centers for Disease Control in places like hospital settings for bloodborne pathogens and for other diseases like tuberculosis there have been recognized controls prescribed by Centers for Disease Control that establish control mechanisms for employers to prevent transmission of those types of diseases. Likewise, here in the state, with the state's public health orders, those recognized controls for mitigating exposure to COVID-19 have been delineated within public health orders. And as well within what's called COVID Safe Practices, Altogether New Mexico, publication from the state's Economic Recovery Council that was set up to establish control methods for COVID-19 transmission. Those documents, those publications and orders present recognizable and feasible methods to control the spread of COVID-19 in workplaces. And that helps to establish a recognizable and feasible duty for an employer to implement measures like those to control workplace spread. So under OSHA's general duty clause, an employer has a responsibility to engage those control mechanisms. And so the public health orders do dovetail with the OSHA Act's general duty, and through the rapid response process, our department is able to ensure that employers are meeting those meeting those requirements and recommendations published in public health order and COVID safe practice documents.
Thank you, Mr. Genoway. And that was a great segue to my next question is how logistically or the process fits with the rapid response if this rule were changed, and is that going to be an added effort on behalf or that the NMED would be utilizing for I guess enforcement or oversight of New Mexico businesses?
Thank you. I think I understand the question, and if I don't fully answer, please let me know.
Sure.
The department has, of course, been engaging in rapid response activities and receiving reports from employers of positive cases since the emergency temporary rule was put in place on August 5th. This rule would simply continue that process. As far as enforcement of the rule would be essentially the same as our existing enforcement of reporting requirements for other types of reportable conditions that were already contained within subsection A of and B of the rule that we are here to request amendment for today. The department has enforcement authority to conduct inspections, issue citations under the state OHS Act and within the New Mexico Administrative Code 11.5.1 general provisions, and further developed in the department's policy what we call our Field Operations Manual for the conduct of investigations and inspections, including provisions for issuance of citations and penalties associated with violations of standards and rules just like this one.
Madam Hearing Officer, Mr. Genoway, thank you for answering those questions. So that was exactly where I was, the information I was trying to discuss. And so in terms of enforcement and authorities and resources, if it's the New Mexico Environmental Department, the OSHA program, with the proposed rule, as I understand, looking at the public rapid response data back from July and August, and then what we've had in terms of this surge on the rapid response, it's been almost exponential. So my question is more about how does the Environmental Department, OSHA division, foresee incorporating this rule when I know there's been a great deal of additional need for rapid responses and enforcement because of the ongoing surge. And so I guess it's more of a resource, both human and financial resource issue, and a additional burden on the NMED. And how does NMED foresee that dovetailing again with the rapid response process, where I understand that PED and other departments within the state have also followed up on rapid responses. And so I guess it goes to the authority, and then who's going to be responsible for the enforcement or oversight of, I guess, implementation of this rule.
Thank you. And to your initial point, it absolutely has been a challenge for the department to keep up with the surge over the last couple of months with positive cases. And at around the time that the department put forth the temporary rule in early August, we also sought additional resources for staffing to assist with the rapid response and other COVID-19 response efforts as well. As part of that process, we were able to secure a federal Department of Labor dislocated workers grant through the state's Department of Workforce Solutions to bring on an additional 26 temporary employees to assist with the rapid response process, which timing-wise was critical and somewhat fortuitous in assisting us to try and keep up with the surge and make sure that we're able to still respond to all those positive cases. It's been a challenge, but for the most part, we've been able to keep up with it. It has been more difficult lately, but we are also resource-wise developing through a contract with a third party a system of self-completion on the part of employers for many of the rapid response cases to help alleviate the workload so that we can focus on employers that are in the greatest need of assistance in rapid response. So employers that, especially large corporate employers that have been through many rapid responses, will be able to essentially work through the rapid response and document that on an online portal that we are in the process of creating, and I'm hoping to have active by next week. That will allow us to then focus on employers that maybe it's their first time through a rapid response, or employers that have had a high number of positive cases and rapid responses within a short time period, say 2 weeks, that we can focus our efforts on those employers to prevent outbreaks and to assist employers that are less familiar with the rapid response process. To the latter part of your question, enforcement of this rule is under the responsibility and authority of the department solely. For all employers within the department's jurisdiction, and that would include employers within education, corrections, healthcare, long-term care, that other agencies are handling the rapid response portion of the control process for. So NMED will still enforce the 4-hour reporting requirement of this rule. However, once a case is reported, then the agency that has the greatest level of expertise in not only handling a rapid response with, let's just say, for example, a nursing home, but also has that experience in handling the response process for residents of a nursing home. And so the rapid response process is being assigned to the agencies based on their expertise. Right now, the majority of rapid responses are being conducted by the Environment Department. Approximately 70% of the approximate 20,000 rapid responses that have now occurred since early May. Approximately 14,000 of those would have been handled by the Environment Department.
Thank you, Madam Hearing Officer. Mr. General, I think I just have one more question for now. So under OSHA, I know a number of states are running their OSHA, the OSHA requirements and compliance. So are we seeing across the country other states pursue similar rulemaking or mechanisms within their states? Do you know?
Yes, thank you. And several states have promulgated emergency temporary standards for varying aspects of the pandemic. This type of reporting rule, I believe, is still the only one of its kind. There recently a similar rule for requiring that employers provide information on positive cases within the workplace setting in California, for example, has been promulgated. Other types of rules in other state programs, state OSHA programs nationwide, include more prescribed controls like what we have with public health order and COVID safe practice documents. There have been a few states such as Virginia, Michigan, and Oregon that have issued emergency temporary standards, like I said, with more specifically prescribed controls for different aspects of control of work in the workplace, mask usage, distancing, and things like that.
Thank you, Madam Hearing Officer, Mr. Dennehy. Those are all the questions I have for now. Thank you.
Thank you, Member Sweeney. Are there any other board members that have questions? Yes. Member Trujillo Davis, I think you're on mute.
Okay, looks like when you're calling in from your phone, you have to unmute in 2 places. Okay, thank you. I just have a few kind of follow-up questions to Member Sweeney's questions. I'm just, for my clarification, if an individual has to report their test results to their employer, how does that kind of fit in with HIPAA requirements? Has there been any analysis of that type of regulation and make sure there's no conflicts there?
Yeah, thank you, Member Davis. And yes, it certainly is an employer's responsibility to ensure privacy of cases, of medical information for employees. Those requirements are not contained within the OSHA statute. Those are derived from other statutory and regulatory requirements placed on employers, placed on medical professionals, et cetera. We will certainly, as we are working through the rapid response process, our rapid response specialists are instructed to provide general information to employers that will assist the employer in protecting that privacy information. But ultimately, it is the employer's responsibility to comply with those requirements.
And are there any protections for the employee if they have a positive test rate? Can an employer let that employee go for having a positive test rate?
There are certain protections from discrimination, again, in statutes outside of the OSHA statute. However, within the OSHA statute, there is a non-discrimination provision that would make it unlawful for an employer to discriminate against an employee solely for the reporting of an injury or illness. So there are some protections under the state's OSHA statute, as well as discrimination protections under statutes outside of OSHA. I'm sure on a case-by-case basis, there are legal nuances regarding what is allowable on the part of an employer.
And when I ask that question, I'm really thinking of, the people who are working in fast food type positions or, positions where they may not necessarily have the resources. So thank you for answering my question. And kind of switch gears a little bit here. I'm wondering, as an employer is required to make this notification, make this report, does it affect their, do they have to file it on their OSHA log? I think it's a 301 form. Does it affect their total case incident rate?
Thank you for the question. Not necessarily. The employer must An employer must go through the same process as any other type of injury or illness to determine whether that injury or illness resulted from a workplace condition. And in many cases, a COVID-19 positive case may not result from a workplace condition. And so the recording requirement is, again, dependent upon whether there is a likelihood that case was transmitted to the employee within the workplace. There is in place, and again within the section of the rule that we are looking at here today, 11.5.1.16, the board has incorporated federal OSHA's regulation 29 CFR Part 1904, and that federal regulation has the recording requirements for an employer to record injuries and illnesses on the OSHA form 300, 301 or equivalent form. And so the employer would be required to look at that federal regulation to make a determination on recordability on those forms. So short answer is an employer has a responsibility to make a determination, but not in all cases would that positive case that's being reported be required to be recorded on the log.
And what kind of impact would this have on an employer if they needed to make it a recordable on that? And maybe I should back up a little bit. Is there a difference between reportable and recordable?
Yes, there is, and those differences are, of course, the reason why that there are separate provisions within the NMAC for referring or incorporating the federal standard for recording of cases and having the separate requirement to report certain conditions.
Okay, so a recordable one would affect their total case incident rate.
That's correct.
Okay, and do you know what kind of impact that could have on an employer?
Thank you for the question. I'm not sure I understand the question. There are different potential impacts of recording cases from an OSHA standpoint. OSHA's recording requirements, of course, are separate from reporting or recording requirements from other agencies such as Workers' Compensation Administration. So I'm not sure if that's where your question is coming from. As far as purely for recording requirements, it may have an overall industry impact in illness rates among industries. Illness rates reported for a specific employer may be taken into account in programming of OSHA inspections, future inspections based on strategic targeting of employers or industries with higher incidence rates of illness or injury. So it can have an effect in those ways. I'm not sure that answers your question. I'm happy to expand if necessary.
Yes, it does. And I can ask it a different way. And maybe I didn't ask it very clear. But I guess I'm asking what kind of potential impacts, and I know just enough in this realm to get me in trouble. So I think that they are required to, or they report to different type of database organizations like ISNet and things like that. And I'm wondering, is there a potential for recordable incidents to impact their business later on, depending on, obviously we're talking about a number of industries here, but is there a possibility that we could have it could negatively impact some of these businesses, or is by getting more inspections later on? Just if you guys have done any sort of kind of future outlooks on potential impacts for companies.
Thank you. I think that helps. So, so for future impacts directly from an OSHA perspective, we develop strategic plans and targeting systems based on a number of different things: overall industry rates for injuries, fatalities. Usually, when we look at injury and illness, we look at specific types of hazards that are associated with those injuries and illnesses. For example, struck by hazards or amputation hazards within manufacturing industries. And so we're looking for specific types of illnesses or injuries that would provide a basis for targeting. Question of whether there would be a basis for targeting on positive COVID-19 cases, I think is very dependent on the course of this pandemic and whether it whether it continues for a long enough period of time for the department to collect. Well, the data is being collected, but to analyze that data and develop targeting systems based on that data. It's certainly a possibility that I wouldn't preclude, because it's an effective way to target our resources in reducing injuries, illnesses, fatalities. And so certainly something that we could use moving forward. And again, I wouldn't preclude it. As far as how the industry might use that data, of course, OSHA doesn't require that an employer report that data to within the industry, but as you note, Member Davis, there are resources that large organizations, and ISNet is certainly one that I know is used within the oil and gas industry to collect data on employers that includes injury, illness information and compliance histories, essentially that are reported by those employers. How that data is used in contracts and business, I think is, it's very dependent on how those large companies that are making those contracts are looking diligently at the information that's being presented, and I would hope that they would look at that information objectively. But what the potential outcome is of COVID increase in rates due specifically to COVID and how that might affect business, it would be very difficult for me to try and project or guess at that.
Thank you, Mr. General. You answered my question just far and beyond. So thank you very much. I appreciate your time. And I don't have any more questions.
Thank you. Any other members have any questions for Mr. Genoway? Yes, Mr. Volkerding.
Yeah, this is Member Volkerding. To follow up a little bit on the under the state is following the federal requirements. Form, equivalent form. In terms of reporting what's being required, is that correct?
Excuse me, Mr. Volkerding, I didn't get that last part of your question. You cut out.
I'm sorry. So my question was the reporting aspect. Let me.
Your audio is cutting out.
One minute. Okay, now?
Let's try it.
Seems to have a bit of a connectivity issue going on.
Member John, you might get a better reception or a connection there if you cut your video. You might be able to have a little bit better connection.
Not sure if he can hear us. I think while he's taking care of that issue.
Can you hear me
I'll
now?
go ahead. Okay, great. Yes, we hear you. We don't
Yes.
see you, but we hear you.
Okay. Now?
There we go.
Yes.
Okay, I think my internet crashed for a minute. So am I hearable?
Much better.
Yes. Okay. I apologize. So my question is, the recording aspect on OSHA Form 300 follows with the federal government, but this reporting aspect that's being requested today goes above and beyond what the federal government requires. Is that correct?
That's correct.
Okay. And then I don't know the answer to this. So are there other illnesses that are required to be reported in the same fashion?
There are no other reporting or recording requirements in New Mexico that go above and beyond the federal reporting and recording requirements. In other states, there are some, not in New Mexico.
Okay. Okay. Thank you. In terms of an employee testing positive, what is the standard for that? And let me explain why I'm asking the question. I myself got COVID during July. I was actually quite sick from it, but never tested positive on any of the nasal swabs. They diagnosed me via a chest x-ray. And so I guess my question is, when would an employee tell an employer they're sick?
Thank you for the question. That's a very good question. Certainly, a positive test result would, and that positive test result being reported by a medical professional would be the trigger. If an employer is informed that a medical professional has provided a diagnosis of positive COVID-19, I believe that positive reporting, because it comes from a medical professional, would meet the same reporting requirement as a positive test.
Okay, and part of the reason I asked that is that, so I was at the hospital and they made their diagnosis. To my knowledge, no one ever contacted the Department of Health, or there was no follow-up at all on my case with anyone. And so I guess I just wanted to make sure that it's clear who's supposed to do what. I've known other people who have tested positive, with a nasal swab, and then they have been contacted by the Department of Health, and everything seems to really move along well. With me, there was absolutely nothing. And so I guess that might have been the part of the hospital falling down. I don't know. I guess I'm just kind of, a little concerned that when we talk about enforcement, if it gets into this gray area between an employee knowing or not knowing, or whether someone's going to end up getting in trouble, basically, because there is this confusion.
Thank you, Member Volkeding. And I will say that, as I described earlier, our OSHA policies and procedures for conducting an inspection and issuing a citation are very deliberative and go through a very structured process to ensure that we establish certain elements of employer knowledge and a fact-based information to establish that a violation has occurred. And I believe through that process we would ensure that the information on a positive case is very strong, fact-based, based on medical information, and ensure that in determining whether the employer had the actual knowledge or constructive knowledge necessary to find a violation, that our process would be very deliberative to ensure that excuse me, I just slowed down because of the reverberation there. That we would, prior to issuing any citation, we would ensure that we had fully established a violation, meeting not just at the face of what the standard requires in reporting, but that it meets all of the legal requirements, legal sufficiency to before we issue a citation. I know certainly with COVID-19, there have been it's the testing, the notification processes, in some cases have been a work in progress, if you will. And obviously we would take those things into account and not put more burden on the employer than the law requires. Okay,
that helps. Thank you. Because of COVID-19 and the fact that probably having open meetings, and public displays of what the Bureau may be wanting to do, what kind of outreach was available to the community on that this is where the Bureau wanted to go?
Right. So thank you for that question. And through this process of rapid response, temporary standard, and going into the permanent standard, of course, we've had direct contact now with thousands of employers through the rapid response process. We've walked them through that process. We've explained reporting requirements to them. We have sent out mass emails to businesses based on directories that we have within the Bureau. Of course, we've issued a number of press releases on the rapid response processes, surveillance processes, reporting rule requirements over the past 4 to 6 months.
Okay.
And we've engaged in our industry partners, with our industry partners. We have partnerships with construction industries, for example. So yeah, we're not just enforcing rules. We've been conducting outreach, and we're not just an enforcement bureau. We have an enforcement section, which is very robust, but we also have a cooperative program section where we work one-on-one with employers, as well as compliance assistance where we work with industry, labor groups, and so forth.
Okay, no, I appreciate that very much. I had 2 more. What were they? I don't know if you had an opportunity to look at, there were a couple public comments that were received. One of them was from Chris Meckles, I think is how you say his name. And he brought up some issues in terms of whether the Environment Department and whether this board was the appropriate venue versus Department of Health, Department of Public Safety, things like that. Did you have a chance to did you see that public comment?
I'm sorry, Member Volkerding, I did not see that comment.
Okay. Well, then it gets too technical. I don't want to necessarily go through it. I wanted if you had seen it and if you had a rebuttal or a comment, that'd be fine. But if you haven't, that's fine as well. So my last question. So right now, what is being asked of the board to approve is already required. Is that correct?
Yes.
So help me understand, if the board does nothing, it's still required, correct?
Member Volkerding, the current standard rule is a temporary rule. Whether that rule would sunset at the end of its 120 days as a temporary rule, or whether the action of this board would and how the outcome of the board's decision would affect the temporary rule is something that I'm uncertain of. I think I would have to defer to counsel to try and answer that question. If it's one that can be answered today, I'm not certain.
And so then I guess a follow-up, and it's probably maybe something you can't answer. I'm trying to understand what the benefit is to the state if the board rules on this petition, or what the damage to the state is if the board were to deny the petition. And so that's what I'm trying to wrap my head a little bit around.
And thank you, Member Volkerding, and I'll try and answer as best I can that question. The department issued a temporary rule. Under the statutory provisions for issuing of a temporary rule, the department is required to present to the board a proposal for making that temporary rule a permanent rule. And so I do believe that and I welcome our council's follow-up here, but I do believe that that the permanent rule process is the appropriate path forward to achieving what we're trying to achieve in reporting and responding to these positive cases.
Okay. And I guess during one of the other questioning sections, it was discussed that some other states have done some, temporary emergency provisions similar to this. But it was, again, temporary was what I heard. And I guess I'm just not seeing necessarily the permanence of a necessity of permanence. If hopefully, and it's a hope, we have a vaccine and this is going to, hopefully begin to become better within the next 12 months. It strikes me a hair of a precedent that I'm not sure that at least I'm necessarily comfortable with, in terms of since we don't have any other illnesses that we've done, this within the rule. I'm just trying to, that's where I'm really struggling. And so I guess anything else you have maybe to help me kind of sway one way or the other would be helpful.
Thank you. I would say that in the 20 years that I've been with the OSHA Bureau, there has not previously been a need to issue a temporary emergency standard. COVID-19 is the most widespread and highly impactful hazard that I have experienced, and quickly emerging as an emergency that I've seen in my 20 years, and that I believe OSHA has ever experienced in its existence. Emergency temporary standards are rare nationwide, and the number of states that are issuing emergency standards, I think, is indicative of the need to act quickly. We would certainly, like to have had the time to engage in the longer rulemaking process to put a standard like this in place. Especially had we known that the pandemic would last as long as it has lasted, and appears that it will continue for some period. And I certainly agree with your hope that the vaccine will be widely available and widely used in a time frame that wouldn't necessitate a longer term standard than 120 days, which is the limit for a temporary rule. Unfortunately, we've already seen that we've far surpassed that, and I foresee that it will continue for well more than an additional 120 days. I think you can make a distinction between the need for the emergency standard and the need to make the standard, when I say permanent, of course, I do foresee that at some point it won't be needed. And at that point in time, that it's no longer needed. I think there are a couple possibilities that the department would consider, including, if you will, coming back to the board to take this off the books, or to promulgate a standard that is more comprehensive and forward-looking in more general pandemic prevention. But I do believe that a standard that is longer than 120 days is needed to see us through this pandemic.
Okay, thank you. That helps a lot. I completely agree. I think 120 days, this is not going to be over. Permanence is just kind of where I get hung up on. But no, I appreciate, and I know you guys have had an extremely difficult task and still do. And so I don't mean to diminish that in any way. And as I said, I had it, and it was very unpleasant. And so I know it's very real. I'm just trying to look at it from a couple different perspectives. So thank you very much for that input. And Madam Hearing Officer, that's all I have.
If I may, excuse me, I'm sorry. I would like to respond if that's appropriate now, or to discuss. But also, we've been going at this for about an hour and 40 minutes now, and Mr. Genoway's been on the hot seat for that time. It might be appropriate to take a short break, if we may. I'm sorry.
I think you're muted, Mrs. Garcia.
You're muted, yes.
Okay. Thank you, Mr. Spencer. I think if you could go ahead and close this little loop with your response to support Mr. Genoway's statement, then after your response, then we'll take a break.
I'm trying to do the double unmute now, and I'll try to work back from the conversation points from the chairperson. So, although this is in fact a permanent rule change, it's an amendment to the current rule, and it is much more in line with legal precedent to do a formal rule processes, which what we're doing now. However, as we all know, COVID-19 is an emergency. And if the board doesn't pass this rule, doesn't pass this amendment, we will continue having to determine every 100 days if there are exigent circumstances that the environmental secretary needs to find in order to do an emergency amendment. And that's the thing. If we put this amendment on the books, this becomes a pattern like you said, to deal with COVID-19, and that's how it's specifically mentioned right now. But I do want to bring to the board's attention some history here. The 1918 Spanish flu. 1968, there was another Asiatic flu that killed 1,100,000 in the United States. 1957 and 1958, there's another Asian flu pandemic. And as recently as 2009, if we remember the avian bird flu, where 60.8 million cases worldwide, and in the United States by itself had over 12,000 deaths. So although a pandemic and novel coronaviruses or novel viruses are really new to us, they're not new. This global pandemic that we're enduring right now is very much in the forefront, very much in our hearts and minds right now. However, the idea of a novel flu virus is nothing new. It's going to come about again. And you look at and these are listed, those that I mentioned are listed on the CDC's website. My mother has lived through 5 out of 6 of these. So in her lifetime, there's been 5 pandemics that affected a large portion of the globe. So the permanent rule is something that it is much more, the legal requirement is to do the permanent amendment. The emergency amendments are something that are only done for exigent circumstances, and every 120 days, Secretary Kinney would need to evaluate whether or not there were exigent circumstances to necessitate an emergency amendment for the reporting requirement. But the cleaner and direct route, and the route we're supposed to use, is this amendment route. Okay, and just to refer to my notes. One thing too, you spoke about the time frame for when an employer learned of a test or a positive test result with your particular circumstance where the Department of Health didn't follow up with you. I don't know if your employer made a report to the Bureau or not, but if you look within the terminology that we're requesting an amendment is the word notice instead of learning of a positive cause. So notice is a well-established legal word that has been used throughout the legal concept, legal terms, to mean a certain thing. It's not, how do you learn of something versus I was notified. Notified is
Excuse me,
well-established.
excuse me, Mr. Spencer. Your testimony, you're starting to sound like you're giving testimony. If you could pose questions to your witness rather than give testimony, you will have an opportunity for a closing statement later.
Okay, sure, not a problem. I was defining the word notice, and I'll step back for that, and I'll throw that to the closing. So, all right. So the thing most directly I wanted to speak about it is the temporary emergency rules versus the actual amendment process, and we've discussed that, and I think if you have any questions, I'll be happy to take those now. And that was the main thing I wanted to respond to and to get out there.
Thank you, sir. All right, this does seem like a good point to take a break. Let's go ahead and take a 15-minute break and come back at 11. And we'll continue with the hearing at 11 o'clock. Okay? Thank you.
Hey, Pam, can you hear me?
Yes, I can.
Yeah, hey. It's going fairly smoothly. I don't, that background noise every once in a while. Do you hear that as well? It's,
Yes, and I've been trying to mute people. I haven't muted you and haven't muted the hearing officer, but I've been trying to run up and down the list.
right,
muting
yeah. I don't know what it sounds like a lawnmower or something going on.
Yeah, no, I know. Yeah, so we'll just, and then I've been monitoring the email box as well to see if there's any public comment.
Okay.
So, at any rate, I think it's going fine, and thank you for what you're doing.
Oh, you're welcome. Thank you as well for
Well,
keeping everybody on mute. That really does make a
yeah,
difference.
that's what I'm watching for, is just to make sure that people stay muted and
Yes.
so that cuts down on that background noise.
Mm-hmm.
Anyway.
Oh, did you hear that? That sounded like galloping horses.
Oh, it was probably it was me, as I just shot off an email to someone. So, yeah.
Oh yeah, your keyboard. Okay.
No, I'm trying to keep people muted as I can.
Yeah,
Obviously,
no, you're doing great. I appreciate it.
leaving you unmuted so that if you need to jump in and slow somebody down, you can.
Yeah, yeah, it's hard if I have to get my hands off the keyboard onto the other keyboard. Hey, Carla,
Yes, ma'am.
I'm a little confused on which exhibits were marked, so I'm going to call you later. Maybe we can clarify that.
Okay. And I guess when when the petitioner wraps up, we can also clarify on that record what was admitted. But we can also talk offline later.
Okay. Well, if you're going to do delibs, I'm going to go. So,
Yeah.
yeah.
Okay, do we have our board members back? Let's see. Mr. Duval, Ms. Sweeney, I don't see them. Mr. Cates, there he is.
Before we go on the record, I just kind of noticed a chat for me asking about an email, and I can't really get to it. But if you could put that in the email chat to Pamela and not me, that'd be a better answer for you there.
All right. So let's go ahead and go back on the record with the hearing now. So the person who sent the chat question, let me give you the better email address to send public comment to, and that would be send it to the board administrator, and that is pamela.jones@state.nm.us. Couple of more comments from the public, just to make the board aware that we've got a couple more comments in your email boxes from the public. Okay, so back to, let me ask any other board members, if you have any questions for the petitioner, the department, or Mr. Genoway? Yes, Mr. Cates?
Yeah, Chairman Garcia, a question for Mr. Genoway. Is he still there?
Yes, he's here.
Mr. Genoway, so in the rule we're being asked to extend, it allows for a 4-hour window, as I understand it, between being positive and reporting it to your employer. And so I just wanted a question about the origin of the 4-hour window. You know, that it seems like kind of a random figure, especially considering how highly transmissible this virus is. It's very, contagious. It's airborne. It's potentially deadly. I mean, we have a public health crisis on our hands right now. And so I wonder about 4-hour window. Why not 4 minutes? Where does that particular metric come from?
Yes, thank you for the question. We used the experience that we had up to the point of time of the rule. So we had a body of rapid responses prior to the emergency temporary rule being issued. And in our experience, the internal reporting process for an employer sometimes is immediate and direct if we're dealing with a sole location, a local employer, if you will, being able to report something immediately versus an employer that has more of a corporate structure and a human resources reporting system that takes, that may more fully take into account things like privacy issues, needing to even check, in some cases, check with corporate counsel to make sure that the reporting process is in line with internal privacy and HR requirements. So in looking at the experience that we had, we determined that 4 hours was the appropriate amount of time. We wanted to make it as short as practicable. Anything shorter than 4 hours for some employers may have been a bit too onerous. We considered longer time periods too, but again, as you point out, based on the emergency nature of the standard and the need to address things like isolation and quarantine as quickly as possible, we landed on 4 hours.
All right. Does that answer your question, Member Cates? Okay. Any other board members have any questions? Okay. I have a couple of questions. And this sort of dovetails on Member Volkerding's question regarding what happens if the board does not adopt this rule. And Mr. Genoway or counsel for the department might answer this question. I understand the emergency rule is in place for 120 days. I thought I read in testimony somewhere that April 4th was April 2021. Was that the date that it would expire? Is that correct?
That's correct. That there is an emergency amendment that was put in place on December 3rd of the exact same language as the first.
Okay, thank you. So are extensions allowed for the emergency rule? Can the department continue to extend the emergency rule, or is there a limit to how many times they can extend it?
That is an interesting question. Solaria might have an opinion as well. The statement I'm going to make is based on there is a difference in the emergency rule underneath NMSA Chapter 14 and the emergency rule afforded to the NMED department and specifically OSHA. And I want to pull those up. So if you give me just a second, I can get those on my screen and I can speak to the chapter, let's say that the chapter and verse of those appropriate sections of the law. And if I can get those up. Okay.
And while you're looking for that, oh, you found it. Okay, go ahead.
No, please, Chair, Madam Garcia, please.
I was just going to ask, I had a separate question for Mr. Genoway regarding violations to these reporting requirements. I understand you issue citations if there's a violation after you've investigated it. Is there a penalty involved with a violation of this requirement?
Yes, Chair Garcia, there would be likely to be a penalty. Again, our field operations manual has a chapter dedicated to guidance on determining appropriate penalties for different types of violations, including violations of reporting like this one. There's a process that our staff would go through to determine the classification of a violation. A violation like this would either be considered what we call an other than serious violation, which could carry a penalty of up to $13,400. If an employer were found to be willfully violating the reporting requirement, which is a fairly high standard to meet on the part of legal sufficiency on the part of the department's finding, a penalty of up to $134,000 could be issued.
Have you issued any penalties thus far based on the emergency rule?
No, we have not.
Okay. Okay, Mr. Spencer, you found the citation?
I did. Thank you. Thank you for the additional time to flesh those out as well. If I may share my screen so the board can actually look at the law that exists and the differences between two separate sections that have to be read separately in point of fact. So I'm going to share the current section 14.14-4-5.6. It's called the emergency rule, and this is for the general rulemaking procedures that do not apply to NMED, and we'll get to that in a moment. So if I can share, sharing whiteboard. Okay, I think I have to pull this down then. Okay. Can you see what I have open here?
Yes.
Okay. So this is the emergency rule that's encapsulated in the general rules for making regulations, and this is a specific regulatory rule or emergency rule that's in that statute. Now, see in paragraph E that if no permanent rule is adopted within 180 days from the effective date of an emergency rule, the emergency rule shall expire and may not be readopted as an emergency rule. This applies to general rulemaking procedures for which a department has not issued its own procedures. So these are in opposite of the rules. These are in opposite to the rules applicable to the department in this circumstance, and hopefully, okay. And now I need.
Council, if I may interject, the statute you provided is part of the State Rules Act, and so it's not it doesn't conflict with other agencies' rules regulations. So the statute that you pulled up stands on its own. The board, like other is free to adopt their own regulations. So
Excuse me, Ms. Solaria, would you please repeat? You're cutting out.
I apologize. Can everyone hear me now? Yeah. Okay. So I just wanted to clarify for the board, the statutory provision that was presented from the State Rules Act doesn't conflict with any board's regulations that are adopted pursuant to the State Rules Act. So the statute would trump any regulations, and any regulations that the board or any other agency promulgates are adopted pursuant to the State Rules Act, that provision included.
I'm all right, I want to make sure I'm muted. Okay. Okay. And so this technology is getting somewhat out of control for me. I've got 3 different screens going and not one of them is working the way I want.
Okay, so let me just flesh this question out a little bit. So the State Rules Act emergency rule clause says that the emergency rule would be in effect for 180 days and cannot be extended, it looks like. However, you did say that there was a 120-day limit in the, I guess, is there an OSHA, in the OSHA Act, Occupational Health and Safety Act, is there a provision for an emergency rule, and does it have a different time frame?
Yes, it does. Can you hear me?
Yes.
And can you see my screen? Okay. So this is the Adoptment of Regulations that's contained in the employment laws, and this is specifically the OSHA chapter 50.9.1 to 0.25 is the OSHA chapter. So this talks about the adoption of regulations by the EIB as well as what's to be done. So Section A is any person can recommend or propose regulation. Then Section B talks about the process. No regulation shall be amended, adopted, amended, or repealed unless a public hearing by the board, and then notice and those kind of requirements are all contained there. Section C is where there is a visual difference between the general rule and NMAC, and specifically the OSHA Act. So notwithstanding the provisions of subsection B, so the public hearing and the notice requirements, the secretary, that is the Secretary of the Environment Department, may adopt an emergency regulation to take immediate effect upon filing under the State Rules Act. If the secretary determines, one, that their employees are exposed to a grave danger from exposure to substances or agents determined to be toxic or physically harmful from new hazards, or that, and two, that the emergency regulation is necessary to protect employees from the danger. And then in Section D, there's that 120-day deadline from the emergency regulation that it expires. You'll also find within this section regarding the emergency rules, or what you will not find in the section regarding the emergency rules, is any sunset on an emergency, okay, let me run that back. There's a 120-day limit where the rule will expire if it is not superseded by a permanent amendment. And that is opposed to the 180 days that are set in Section 14. But also, what you will not find in this section is a prohibition against a second emergency rule that is the same or substantially the same as you do find in Section 14 of the statute. So the power for the secretary to issue an emergency amendment is contingent on one of these, on only those two things found in paragraph C. Employees are exposed to a grave danger, that emergency regulation is necessary to protect the employees from that danger. And then there's the 120-day deadline. So from the first amendment to the deadline, or when it was to expire, if not replaced by a permanent amendment, was December 3rd. The board and the way the statutes are set up and the notice requirements, all those things precluded us, the department, from actually being able to accomplish an amendment before the emergency amendment enacted by the secretary expired, which necessitated the second one. But the priority is, as we discussed in what we discussed with the chair, Mr. I've got it written down because I didn't want to mess it up, with Mr. John Volkerding, is the preference is the formal rule process, which we initiated immediately after the emergency rule went into place. But because of notices and deadlines and timeframes, it is impossible. It was impossible to get a true amended section before the Environmental Improvement Board before today. So the first emergency amendment expired on December 3rd, which necessitated a second identical similar emergency amendment. Now, as far as the limitations on the secretary, as far as making a third amendment, if he can find these exigent circumstances underneath subparagraph C 1 and 2, that there's a grave danger and the emergency regulation is necessary, conceivably he could. However, the preference is to do a formal rulemaking process that allows for public comment, public participation, as we're doing today, as opposed to doing an emergency amendment every time these two conditions are met. So the ability to do something, the secretary has the ability to do something, yes. However, the preference is a permanent amendment like we're doing today.
Okay, thank you, Mr. Spencer. All right, I do have one more question for Mr. Genoway. You mentioned, you described what rapid response entails. I'm guessing you don't have inspectors go out to the workplace. You probably do this by phone. Is that correct?
Yes, Chair Garcia. As I mentioned earlier, the Bureau has hired a temporary staff of 26 individuals to primarily handle rapid response. So when a case is reported, it is assigned to a rapid response specialist. That specialist contacts the employer and essentially guides them through the rapid response process. In some cases, the employer has taken some steps already, and the rapid response specialist is verifying that those steps have been taken. That's all handled remotely, and in almost all cases resolved within that framework that I described and defined as a rapid response earlier. There are rare cases where an employer is not taking appropriate actions. Those matters are then referred over to our enforcement group rather than being handled by the temporary staff that are engaging those rapid responses remotely. And if I could also, I don't know if this is an appropriate time to do it, I hope so. Member Volkerding asked a question earlier about the comment that was sent in by Mr. Meckles, and I believe that's a December 15th comment. I did take the opportunity over the break to take a look at that. And I believe the question was whether this rule was appropriately placed within the authority and jurisdiction of OSHA. And I would answer that definitively yes, that a rule like this is intended to provide protection for employees, and that's central to the mission of OSHA, the State Occupational Health and Safety Act, and this regulation is absolutely appropriate under our authority and jurisdiction.
Thank you, Mr. James. I did notice, speaking of the public comments, I did read a comment regarding agricultural workers. Could you clarify whether OSHA has jurisdiction over agricultural workers or not?
Thank you for the question. Yes. Short answer is yes, of course we do. And we do conduct inspections among agricultural employers. And we do have, and the board has specific rules under 11.5.4 NMAC covering agricultural workers that are enforced by our Bureau.
Okay, thank you. Thank you very much. That's all the questions that I have. Are there any other board members that have any additional questions? Yes, Mr. Duval.
Yes, thank you, Presiding Officer Garcia. I'm wading through some of the language here, and I appreciate that what is being brought up is hopefully appreciating that the current pandemic situation is likely to occur again, given what the science is telling us about different potential pathogenic pandemics, and I appreciated the history lesson as well. My reading of this is under new hazards. If that terminology is used, would that, if this was to be a permanent rule, that language, new hazards, say that when we experience COVID-21 or COVID-35 or COVID-72, would that be covered under what I'm reading as new hazards? I don't have this section right in front of me right now, but I can find it. I guess the point is, this isn't specific to SARS-CoV-2, COVID-19, that this is moving forward with any sort of potential health emergency that this rule would, if made permanent, would cover that as well. And I'd like to hear a response to that.
Thank you for the question. And in reading the proposed amendment to the rule this particular rule is specific to coronavirus, and so it would be limited to instances where a coronavirus was a novel coronavirus was introduced. It wouldn't cover viruses or other pathogens that represented a pandemic outside of coronavirus. However, I think I mentioned this earlier, moving forward, as this pandemic winds down and we look at this standard and how we might engage in rulemaking to broaden coverage of a standard, to be more inclusive of other types of pathogens, and maybe more specific to pandemic control programs for employers. That's something that we've already started to look at, but for right now, I think it's important to focus on the pandemic at hand.
Yeah, thank you for that answer, sir. I would hope that there would be some forward thinking as far as rulemaking. I mean, my mind can go very wild when it comes to these sorts of what if scenarios, but I mean, you can imagine, E. coli outbreaks in meatpacking plants, or Staphylococcus aureus in medical facilities, or like all sorts of exegees that may well fall under this umbrella. And so I guess that was my question when the term new hazards was introduced into that document, that if that is if that can be an umbrella term for potential future problems in this medical/ecological space.
And we have engaged a group to collect information on pandemic prevention standards in other states nationwide, so that we can develop a more comprehensive standard that we'd like a standard that lasts, right? That will handle that will cover a range of potential hazards, biohazards, that can be adapted by industry and something that's easy for employers to keep and to and to engage when needed rather than trying to play catch up like we are now.
That's comforting to know that you're thinking along those lines. I have nothing else.
Thank you. Are there any other questions from board members? Okay. At this point, does any member of the public wish to question the department or cross-examine the department's witnesses?
Madam Hearing Officer, we have one member of the public, Katrina Doolittle, and I will unmute her now. Go ahead, Ms. Doolittle.
Also, could the court reporter go ahead and swear in Ms. Doolittle?
We normally don't swear in for questioning, only testimony.
Okay, all right. So go ahead, Ms. Doolittle. Thank you.
Ms. Doolittle, we can't hear you. Not yet. Can anybody else hear her?
No. Ms. Doolittle, you could try typing in your question on the chat, I suppose, or email to the administrator, perhaps?
She has just, Madam Hearing Officer, she has just chatted that I can read her letter. So hold on while I pull it up. And this is a letter. Katrina Doolittle, PhD, Executive Director, Environmental Health, Safety and Risk Management, New Mexico State University. And
okay, excuse me, sorry to interrupt you. I just want to make sure this is the point where public can ask questions of the department, but public testimony can be given later. So I just want to make sure we're not talking about testimony, we're talking about questions for the department. Okay. Okay.
shall I continue?
Yes, go ahead.
Okay. Per the published notice, quote, the department undertakes this rulemaking pursuant to its duty to protect the health and safety of employees arising out of and in the course of employment, close quote. Please clarify the reporting requirement as it applies to the workplace. Currently, we are required to report all positive reports by employees, including those where employees are 100% teleworking. We have been notified that this reporting is required regardless of potential for exposure in the workplace. Community-acquired exposure to SARS-CoV-2 and positive reports of COVID-19 should not be included in workplace reporting of illness and exposures. Therefore, I request that the NMED modify the record keeping and reporting to clarify reporting of an employee tested positive for the novel coronavirus be limited to workplace exposures. And that's the conclusion of the question for Mr. Genoway.
Excuse me, could Ms. Sweeney please mute? Thank you.
I appreciate the question, and in developing the rule, we did consider various aspects of employee exposure to the virus in the workplace. And so if an employee has contracted COVID-19 and has the potential to be in the workplace, that exposes other employees to the virus. In order for the department to ensure that exposures in the workplace are controlled, it's important that we receive notification of all employee positive cases so that the department can verify whether or not that employee has been in the workplace and potentially exposed other employees. There have been a number of reported cases where employees are teleworking but come into the office or come into the workplace for short periods of time for various reasons. And so in trying to parse out whether an employee is teleworking and what teleworking may mean regarding the length of time spent outside of the workplace or inside of the workplace, we want to take out that element of question where an employer might not report a case where an employee is teleworking but is coming into the workplace at various times and may expose other workers. And so I can understand and appreciate that in many cases, workers that are positive and teleworking may not expose other employees in the workplace. It's still important for reporting purposes that we track and verify those cases to determine whether or not there is the potential for exposure. And so we kept the reporting rule at reporting of all positive cases among employees.
Yes, Member Vokerding?
I had if I could ask a follow-up to that, though. In listening to Dr. Doolittle's letter, it was, she said 100% teleworking. And I understand your point that sometimes 99% they're teleworking and that 1%, there could be an issue. But I guess to go to the spirit of the question, for people who are 100% teleworking, and they end up reporting, and then, and correct me if I'm wrong, but then that is going to get put on the daily email that goes out to the state about different companies. Isn't that maybe misrepresenting what's happening in that company if that reported case is truly 100% at home and does not pose a threat to other workers or the public?
And thank you for that question. Certainly something that we considered as we developed the publishing of different reports that the department produces. And within the published reports, we do include comments regarding, and I'll have to look, I can look more closely at the comments that have been included, but we're certainly not in any way trying to misrepresent where cases are occurring, rather reporting on all cases that are reported to us. And in certain reports, like our watch list that has been produced more recently, for example, we're only reporting cases where the department has verified that the employee was in the workplace while infectious. So we're producing both types of reports, and if we need to better explain that to the public, we are certainly happy to do that.
Okay. Ms. Doolittle, do you feel that your question was answered? Do you have any other questions for Mr. Genoway? And you're muted, I think. Oh, okay. Okay, it's not, reading lips. I think you said there's no other questions. Okay. All right, are there any other members of the public that wish to cross-examine the petitioner? You see anything, Pam?
I don't see any hands raised. I can poll the list of participants if you wish.
Okay, if no members of the public wish to ask the department any questions, at this point, we can offer.
Madam
Let's
Hearing
see.
Officer,
Yes, go right ahead, Carla.
I would suggest that because there are IC call-in users on the line, I would suggest that Ms. Jones go ahead and quickly go through the list and ask them if they have questions.
Oh, okay. Okay, that's a great idea. Thank you, Carla. Yes,
Okay.
if you do that, Pam.
Sure. I'm going to go down the list of participants that I know are not board members or members of the department. There is a Brian Homme, and excuse me if I've mispronounced your name. Do you have any cross-examination for this witness? Okay, that was a no.
Oh, somebody.
Eileen Street. Do you have any cross-examination for this witness?
Ms. Jones, you have to unmute them to respond. I'm not showing that they're being.
I am, yes.
Okay. Yeah.
Again, Ms. Street, if you have any questions for the witness.
This is Council Carl Storia. Ms. Street has chatted no.
Okay, thank you. Mr. Guevara, do you have any questions for this witness?
Not at this time, thank you.
Thank you. Ms. Root, do you have any questions for this witness?
No, all my questions were answered completely. Thank you.
Thank you. Ms. Wagner, do you have any questions for this witness?
I do not.
Thank you. Ryan Briggs, Mr. Briggs, do you have any questions for this witness?
No, I do not. Thank you very much.
Ms. Welch, Stephanie Welch, do you have any questions for this witness?
No, I do not. Thank you.
Thanks. Madam Hearing Officer, that is a poll of the participants listed.
Okay, thank you, Ms. Jones. I appreciate that. All right, at this point then, let me ask folks if they are interested in taking a lunch break at this time, or we can move on with the non-technical testimony. Looks like we're willing to move on. Okay, so at this point then, we can hear non-technical testimony and take written statements from members of the public. Remember that any testimony must be limited to the proposed rule changes. The board is unable to take any testimony unrelated to the proposed rule changes. So if the board administrator would go ahead and unmute members of the public that wish to give non-technical testimony one by one at this time.
Yes. I can go down the list and poll again. Mr. Hom, do you have any testimony to present? Non-technical testimony.
Mr. Hom has chatted no.
Okay, thank you. Ms. Street, do you have any non-technical testimony?
Ms. Street has also chatted no.
Thank you. Mr. Guevara, do you have any non-technical testimony to present?
Yes, I do.
Okay, please proceed.
Mr. Guevara, would you please raise your right hand? And are you going to be on video?
Yes, I just turned on my video.
Thank you. If you would raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
Would you state and spell your full name, please?
Felipe Guevara, Felipe, last name Guevara.
Thank you.
Mm-hmm.
Okay, excuse me, Mr. Guevara. You may give an opening statement before your testimony if you wish, or you can go on into your direct testimony.
I'll just probably go directly into my testimony. Thank you. So thank you, Madam Hearing Officer and board members, for your time and attention to our comments today. I am speaking on behalf of 6 organizations and advocates that support workers through New Mexico, and I am an attorney at the New Mexico Center on Law and Poverty, workers' rights attorney specifically. All workers—
Excuse me, would you please slow down for me?
Oh, absolutely.
Thank you.
All workers, including low-wage and immigrant workers, have the right to stay safe and healthy during these challenging times. We, therefore, commend the New Mexico Occupational Health and Safety Bureau, the Bureau of the New Mexico Environment Department, for requiring employers to report any employee's positive COVID-19 test to the Bureau within 4 hours of being informed of the positive test. Furthermore, we support the Bureau's desire to formalize this process that was enacted earlier in the year through an emergency amendment. Nonetheless, we are concerned that the Bureau is not requiring employers to inform the workers when someone employed by the business tests positive for COVID-19, and that the Bureau has yet to provide clear and simple information to workers about rapid response protocols. Moreover, we are concerned that workers are often left in the dark about when and how they should return to work after testing positive or coming in close contact with someone that tested positive at their workplace. Finally, we are worried that employers are not adhering to pandemic health and safety protocols and health and safety measures that were in place prior to the crisis. Therefore, we recommend that the Bureau set up a system that informs an employer's entire workforce that someone at the business tested positive for COVID-19, keeping the privacy of the worker that tested positive in mind. And we encourage the Bureau to take the necessary steps to ensure that all workers at the workplace know and understand the rapid response procedures that will occur before the business can reopen. Additionally, the Bureau should give all workers at a business that is going through rapid response protocols information that clearly and simply explains a worker's rights and responsibilities if they contract COVID-19 or if they come in close contact with someone that tested positive. Finally, we recommend that the Bureau enforce pandemic and pre-pandemic health and safety measures that are meant to protect workers during this difficult time, such as imposing significant fines on businesses that fire workers for quarantining. Once more, thank you for your time and attention, and please refer to our written comment for further analysis of the issues and recommendations I just mentioned. You will also find my contact information on our written comment if you would like to discuss anything we presented further. Thank you.
Thank you, Mr. Guevara. Is your written comments entered as an exhibit, Ms. Jones? Is that an exhibit we need to enter into the record?
His comments were posted to the website and distributed this morning.
And Madam Hearing Officer, once we're done with any spoken testimony, you can issue a ruling admitting anything that was written, that it be admitted to the record.
Thank you, Carla. I didn't hear the first part of your statement. You cut out a little bit.
I was just saying that we could get through anyone who's on the line who wants to give spoken testimony, and when that concludes, you can just state for the record that you've admitted any public comment that was submitted in writing as well.
Okay, perfect. Thank you very much. All right, are there any other members of the public that wish to testify?
Let me continue down the list. Find my place here. Katrina Doolittle, do you have any testimony to offer this morning?
Looks like she said no.
Okay. Miss Root, do you have any testimony to offer this morning?
I do not. Thank you for asking.
Okay. Miss Wagner, do you have any testimony to offer this morning?
I do not. Thank you.
Mr. Briggs, do you have any testimony to offer this morning?
I do not. Thank you.
Miss Welch, do you have any testimony to offer this morning?
No, I'm sorry. I do not. Thank you.
Thank you. Madam Hearing Officer, that's a poll of the participants.
Thank you very much, Ms. Jones. So do any board members wish to ask any questions of the public participant that we did have, Mr. Guevara? Okay. Does the department have any questions for the witness, Mr. Guevara, that gave testimony just now? We wish to cross-examine Mr. Guevara. No? Okay. Does anyone else, any members of the public, have any questions or wish to cross-examine the witness, Mr. Guevara, that gave testimony just now?
I think, Madam Hearing Officer, I can go down the list again and take a poll of those that are participating. Mr. Hom, do you have any questions of Mr. Guevara this morning?
Mr. chatted no.
Thank you. Ms. Street, do you have any questions for Mr. Guevara this morning?
She responded no.
Thank you. Ms. Doolittle, do you have any questions of Mr. Guevara this morning?
She responded no.
Ms. Root? No, thank you. Ms. Root, do you have any questions of Mr. Guevara this morning?
I have no questions. Thank you.
Ms. Wagner, do you have any questions for Mr. Guevara this morning?
I do not. Thank you.
Mr. Briggs, do you have any questions for Mr. Guevara this morning?
I do not. Thank you.
Ms. Welch, do you have any questions of Mr. Guevara this morning?
No, thank you.
Okay. That's all the participants, Madam Hearing Officer.
Thank you, Ms. Jones. At this point, does any party wish to offer rebuttal testimony? Does the department wish to offer any rebuttal testimony after the public
We do not.
testimony? Okay. Does anyone else wish to offer any rebuttal testimony? Okay. Any person who testified and who wishes to make a brief closing argument may do so in the same order as the direct testimony. So we'll start with the petitioner. If you would like to give a brief closing argument, you may do so now.
Madam Chairman, hearing officer, my apologies. We'll stand on our not only our opening comments, but as well as the documents themselves and the testimony that's been elicited today.
Okay, thank you. Any members of the public that testified, Mr. Guevara, do you wish to offer a closing argument?
No, I'll just refer to my statements earlier. That's kind of summarizing what we believe in. As well, like I said, while we commend the department for this rule change, we do hope that there are further efforts to formalize some other processes that could be helpful to workers, particularly low-wage and immigrant workers. Thank you.
Thank you, sir. Okay, any of the information provided by the public is now in the record. Anything they provided, letters and comments, etc., is now in the hearing record. I'd like to thank everyone who participated in the hearing today. I want to make note that the board did have a quorum today. I want to ask the board members, would we like to go ahead and deliberate after the hearing is closed? Do we want to deliberate today and decide on this proposed rulemaking?
Matt? Yes. Yes.
Okay. I'm seeing a lot of nodding heads. Okay. So let the record show this hearing is now adjourned at 11:58 a.m. The hearing record is closed as well.
And
Thank you, and I'm going to sign off.
correct. Thank you, Madam Court Reporter.
Thank you.
Thank you, court reporter.
Thank you all.
Ms. Garcia, a couple of logistical things is I have a updated statement of reasons that I would like to email in for your review, as well as to inform you that, of course, because of the second emergency amendment, the actual iteration of the proposed amendment is slightly different. Those are nuances that we can work out for sure with the record department. That shouldn't be a problem, but I just wanted to let the board know that those two little things.
Thank you, Mr. Spencer. I wish you had mentioned that before I closed the hearing record. Carla, do you have any suggestions on whether we should?
Yeah, to clarify, Mr. Spencer, are you talking about what's to be submitted to the state, the records department? Or are you amending an exhibit that was already submitted because the record is now closed?
Sure. The record is closed, but the proposed statement of reasons was just a proposed statement of reasons. It's not a final document for the board. Right. So what I was going to do, if it's allowable, is present a second proposed amendment, statement of reasons rather, that incorporated the nuances of the second amendment. It would be a more accurate potential adoption of the statement of reasons for the board. That's it.
Yeah, Mr. Spencer, you and I can work out the language for incorporation in the board's adoption eventual decisions.
Okay.
Oh, Mr. Spencer, you're on mute.
Of course I was. I was very eloquent and determinative. So I'll email the statement of reasons to you. And then as well as the citation, the literal portion that's going to go to the records department is going to be slightly different because of the second amended, if it's adopted, if the second amended emergency amendment. So that is going to be slightly different than what the board has before them right now. And I'll send that iteration to you as well.
Just to be clear, counsel for the board, we're going to be deliberating over the language as that was submitted, not any changes. We're going to be deliberating over what was submitted previously and making a decision on that language. Correct?
That's correct. Oh, hold on 1 second. I'm trying to review what was previously submitted by the department.
The only change is going to be an additional caveat added in the note section that states there is a second amendment. If you look at it's a clerical thing. It's no change in the language, but the first copy that you have of the proposed language has the August 5th dated emergency amendment. However, because there's been a second one, there's going to have to be an additional, sticker there that says, emergency amendment 12/3/2020. It's just truly a clerical. It has to be done because there has been a second emergency amendment. There's no change in language, but there's a change in the tiny subscript that needs to be made because of the second amendment. So the emergency amendment from 12/3. To clarify, I'm very sorry. It's not nearly as technical or problematic as I made it sound. I'm very sorry.
Okay, great. As long as the language is the same, the language that we would or would not adopt is the same. Okay. All right. So now
I'll just send both the new draft of the statement of reasons and the new draft of the proposed language to Ms. Solaria independently, so it won't conflict with any deliberations.
Right. And to clarify, Madam Hearing Officer, the exhibit was essentially a proposed order, so there's no issue with us adding clarifying language or anything like that.
Okay, great. Okay, so any comments from the board? We can now start deliberating over whether to adopt this rule or not. So do I have any board member comments? I don't see anybody raising their hands. Okay. Oh, okay. Member Cates, go right ahead.
Yeah, Chairman Garcia, I think the board ought to do whatever it can do today to contribute to the control of the spread of the virus. And that's the gist of my thought. I could go on and on here and would happily engage anybody on that one, but yeah, that's it. Thank you.
Thank you, Member Cates. Yes, Member Bogardine.
So my comment was probably embedded in some of my questions, and I don't necessarily know how I completely feel about it, to be honest. It's, there's at this point, there aren't any other illnesses that are listed as something that needs to be reported to the state. So this is a new direction that the department would be taking. And I'm not saying it's necessarily a bad direction. I guess I want to make sure that the decision is based on, thinking about potential precedent for the future and not just kind of a knee-jerk reaction to the crisis that we do find ourselves in. It's a real crisis. And I do think that, I did like Mr. Genoway. He was talking about, coming back at some point with more of an overarching approach to, what will definitely be ongoing new outbreaks. And I think that that's an important plan for the Bureau to do. My hesitation is I don't see where the state is hurt if the board were to deny the petition solely because there is remedy that can be taken by the secretary. I appreciate that rulemaking is a better process than merely executive orders. I'm just wondering if there's been enough thought put into this. Again, just given the fact that there are potential, as Dr. Duvall pointed out, you can have all kinds of outbreaks, and so it's somewhat limiting ourselves to this one thing, and maybe it's a good first step. I don't know. I guess I'm just kind of struggling with whether we're doing something to just feel like we're doing something, even though the remedy is already there, and if maybe at some point the Bureau should look at a more encompassing change. So I don't know. That's what I'm struggling with.
Yes, Member Duvall?
So first of all, and I didn't say this at the outset, John, I'm glad that you made a very good recovery, and sorry that you had to go through that. But yeah, I'm at a little bit of the same situation as Member Volkerding in that, I'm encouraged that some of the language does seem to encompass potential future situations. I think that is forward thinking by OSHA and the folks that have devoted some time to this, because you can imagine that it wouldn't necessarily need to be a large scale global pandemic, but we're in a state where we have meatpacking plants that there could be a Campylobacter outbreak at a specific site. I mean, just general reporting of illness I find to be refreshing. I mean, if someone is in an oil field and they get their arm chopped off, then yeah, obviously that gets to be reported. But, that's sort of how we think about OSHA, whereas, biological illness, viral infections, things like that, I personally feel like that should be part of the overall portfolio of reporting. And I don't think that that's overly burdensome. I think that it is very much a part of protecting workers, and especially especially the most, some of the most vulnerable people in our society. And I think that a stringent reporting situation and something that is made permanent is very much needed. And that's where I fall on it. I have nothing else to say. Like I'm very much in favor of, I understand some of the concerns, but I think this needs to be a permanent thing. If anything, I would like the language to be expanded. But as it stands now, I am firmly in favor of how it's articulated. And I will now shut up, and you can.
Yes, Member Davis Trujillo? I think you're muted. There you go.
Yeah, it's taking just a second to unmute. I have concerns. I want to echo Member Duvall's comments on, kind of looking at the overarching picture of potential future pandemics. But I do have a lot of concerns of the way that the proposal is currently written, and kind of lack of clarity in enforcement and being able to carry it out for different businesses. I'm concerned that it will not be applied fairly just because of the lack of clarity, fairly across the board for all, from corporations down to small business owners, and that it doesn't seem like it'll be truly protective of the maybe low-income workers or migrant workers, just because of the fast pace that this is being proposed, and that the NMAD is doing their best to adapt to the changing environment, but it's so fast paced that there is some lack of clarity there. And then my last point on this is I'm concerned that if we enact this and there is lack of clarity, that the consequences on small businesses could far outlast the pandemic. And to me, that would be a tragedy on top of this very difficult situation that small businesses are already facing. And I do think that rulemaking is the best path forward, but in this case, given the circumstances, perhaps executive order and revisiting this issue every 120 days is the best path to move forward with. So that's all I have to say on this. Thank you.
Thank you. Any other members have any comments about the proposed rule? Okay, I do have a couple of comments, and I appreciate the comments that have been made. And I think your points are well taken, Member Davis Trujillo, that anytime we consider new rules, I think it's important to consider how they're going to be carried out and whether or not they're necessary, certainly, and how it's going to impact businesses, whether it's going to be overly burdensome for a business to comply with the rule. And if we don't adopt it, what are the consequences of not adopting it? There's been comments that if we don't adopt it, then perhaps they could continue to extend the emergency rule or use some other method. I'm not clear that emergency rule can be extended, how long it can be extended. But I understand why the department wants to make this regular rule, to incorporate it into their regulations. I can see where that is clearer than having an emergency rule. And they made a good point that in this process, rather than the emergency rule, there was not public input. I didn't even know there was an emergency rule out there until this petition came before us. So with the emergency rule, folks don't know about it until the department notifies businesses that are impacted. But going through the rulemaking process, the public then does get an opportunity. So I think it's a good process to go through rulemaking rather than the emergency rule process. Looking at whether or not it's overly burdensome for the industry or for businesses, I think that's a question we should always ask for any rulemaking, whether it's Hazardous Waste Bureau or OSHA, is how easy it is for them to comply. I didn't hear any testimony from the Bureau that they were having any trouble, or that the public, since they went through a process of notifying businesses of the emergency rule, that they've had a lot of problems with non-compliance. I didn't hear that in the testimony. So I think as far as businesses being able to report COVID illnesses, I don't think that's too hard to do. So that doesn't seem like a tough hurdle for them. I think as far as how long this rule is in effect, if it's in effect beyond the COVID pandemic, I think that once COVID is here, it's always going to be here, is my understanding. We may get control of it through herd immunity, vaccinations, et cetera. We may get control of it, but it's here and it will always be here. And there could be mutations, et cetera. So having the rule in place is probably a good idea, to continue to have the rule in place, as opposed to doing an emergency rule over and over and over again until the pandemic's over. I don't think COVID is ever going to be gone completely. So I guess, in my opinion, I support the rulemaking and think it's necessary to do. So, yes, Member Duval?
Yeah, I just need to unmute myself. Yeah, and I mean, based on the prior hearings that have come before this board, I think it's notable that and I fully appreciate the concern for business entities, but I think it's notable that there was no representation from any business interest related here. I mean, I can, and I hopefully this is appropriate, but you know, at New Mexico Tech, where I'm employed, you know, we have fairly stringent reporting protocols in place just to be able to be on campus. I mean, I'm in my office right now. We have, you know, self-reporting. We have, you know, daily testing that's available for everyone that wants to be on campus. I don't see this as being an overly burdensome issue for businesses in the general aim of reducing the societal burden. But I just wanted to make note that there were no, you know, the Chamber of Commerce was not present. There were no small business entities that provided testimony, and so my sense is that might be a little bit of an overstatement to think that they're overly concerned about this if they didn't even show up, if no business entities showed up to this hearing, because they certainly had an opportunity to do so.
Okay, any other board members have any comments?
Chairman Garcia?
Yes.
Just to echo what Member Duval said there. That's a good point, that the business community as such didn't show up, and the perspective I'm hearing from a couple of board members here on the potential effects on industry or business, they seem a little esoteric. I understand the philosophy of the thinking behind it, but to me, it's a little overstated. So, seconding Member Duval's no. Thank you.
Okay, any other comments, board members? Okay, it looks like we would be ready for a motion. Does somebody want to offer a motion? I could go ahead and offer a motion that we can vote on. I move that the board adopt the proposed rule change to the proposed amendment to 11.5.1.16 NMAC
Second?
Thank you. We have a second. Okay, could we have a roll call vote? Ms. Jones?
Yes. Beginning with Member Bitzer, how do you vote?
He's not voting.
Recuse. I'm going to
Oh,
recuse
that's right.
myself.
Pardon me, that's right. Member Cates?
Yes.
Member Duval?
We didn't hear you.
Yeah, sorry, yes, in favor.
Thank you. Member Sweeney? She has written in chat that she votes yes to approve. Member Trujillo Davis?
I think you're still on mute.
No.
Member Volkerding, how do you vote?
No.
Member Garcia, Hearing Officer Garcia, how do you vote?
Yes.
Hearing Officer, you have 4 votes in the affirmative, 2 negative votes, with Member Bitzer recused.
Thank you very much, Ms. Jones.
Motion passes.
Thank you. Okay, so the rule is adopted. The board's decision will be issued in writing, and will it include its reasons for the action taken. And then the board administrator will provide notice of the board's action to each of the participants in the hearing and to all other persons who have made a written request to the board for notification of the action. Is there anything else? Oh, yes.
I had a question. Yeah, I had a question on, I guess, process. So the board is going to issue be working with board counsel to update that with some new verbiage. And so I guess, do we need a motion? Well, I guess maybe 2 questions. Do we need a motion to, do we want the hearing officer to help in drafting that? And then normally the chair signs. Do we want the chair to sign, or do we want the hearing officer to sign that? I don't care either way. I just was trying to understand process.
Right. I guess I was assuming that the board counsel would be writing this, but I may be totally wrong. So, counsel, if you could just let me know who is supposed to be writing the.
Right. I'm happy to do that for the board. I think to Chair Volkerding's point, to keep the record clean and to have it clear, if you could have a motion and vote that I will be working with board counsel to prepare the order and statement of reasons, and then an additional motion as to whomever you decide will sign off on that.
Okay, Chair Volkerding, do you want to make that motion?
Sure. Then I will make a motion that board counsel can work with the Environment Department counsel and with the hearing officer as needed to draft the board statement, order and statement of reasons. And since most of those are signed by the chair, I would include in the motion that the chair continues to sign that.
Okay, do we have a second? Member Duval seconds the motion.
Second.
Thank you. Member Duval has seconded the motion. So the motion carries.
Point of information, is counsel still there?
Yes, sir.
Do I need to recuse myself on this as well?
I'm going to say yes.
Okay.
Okay, so does that take care of all the business for today?
If we could get a quick vote on that, that should.
Oh, sorry, we didn't vote on it. I'm sorry. Okay, so we have a motion and a second. Can we have a roll call vote on that motion?
Yes, beginning with Member Kate. How do you vote?
I'm sorry, what's the motion?
So the motion is to allow board counsel, department counsel, and hearing officer to work together to draft the board's order and statement of reason for signature by the chair.
Oh, yeah, okay, yes. Yes.
Thank you. Member Duval.
Yes.
Member Sweeney, who is chatting yes to the motion. Thank you.
Yes.
Member Trujillo Davis.
Yes.
Thank you. Member Volkerding.
Yes.
And Member Hearing Officer Garcia.
Yes.
The motion passes unanimously with the exception of Member Bitzer, who is recused.
Thank you, Pam. All right. So now, do we have any other business? Do we already know when the next board meeting is in January?
It would be the January 22nd. I believe it's the fourth Friday in January.
If I could ask Chairman Volkerding, where are we at with the
Yes.
case that is pending before us?
That's an excellent question. I drafted a hearing officer report, and board counsel has been reviewing it. And I didn't want to send it out prior to this hearing just to muddy the waters. And so the due date for that is December 30th. And so I hope that I didn't do a horrible job with the report and there wasn't a lot of editing for Carla, and we can get out to the board next week. But I will let her comment.
Yeah, that will be coming next week. I just have to complete my review.
Okay, thank you.
And I do believe we may have a meeting, a special meeting prior to our regularly scheduled meeting in January, but I don't know if we know enough about that yet. Just giving you a heads up.
Okay.
So,
Right then.
The regular, sorry to interrupt, the regularly scheduled, I'm looking at my calendar right now. The regularly scheduled meeting is for the 22nd of January. That's the same time at 9 a.m.
Correct.
Okay, thank you.
at that meeting, are we going to get into the, that case that John just mentioned?
Yes, that will likely, that's probably the only thing that will be on the agenda for that regular meeting. And as the chair alluded to, there is potentially a special meeting that will occur before that for an unrelated matter. And that hasn't quite been settled, but we will be in communication with you all about that.
And so on January 22nd, are we going to, is that like a public hearing? There's testimony and such?
That would be the deliberation meeting for the adjudicatory hearing that already took place. So it will be open to the public, but you won't be hearing testimony. You'll just be deliberating on the prior case.
Got it. All right. Thank you.
Okay, anybody have any other questions or issues? All right, that takes care of our meeting for today. Thank you all very much.
Thank you. I wanted to tell Karen, outstanding job. Thank you for doing
Yes,
that. Very good.
exactly. Thank you, Karen. Wonderful job.
Thank you.
And Ms. Jones, thank you.
And thank you. Yes.
Jones and Carla, thanks.
And Carla. Merry Christmas.
Yeah.
Thank you.
Happy Hanukkah, L'chaim.
Yes, yes.
John, again, glad you're doing well. And
Well, I will tell you, it really has been only in the last probably month that I feel normal. It has taken me months to.
Did you, the whole smell taste thing, was that a thing?
That was not a thing for me, but I had excruciating pain and exhaustion And then once I actually kind of got over that, the entire month of August, my brain did not function at all. I just was I was confused. It was really bizarre. I did not like that part of it. And I like to jog, and only in November was I actually able to start doing more than about a mile. It took me quite a while.
Well, glad you're on the mend.
Thank you.
Right.
All right. Everybody have a good weekend. I'm going to sign off.
All right.
Adios.
Everyone.
I have to say, I'm sorry we missed your Christmas sweater this year. That's one of the tragedies of this pandemic. Is we don't get to see your awesome Christmas sweater.
Yeah.
Well, I'm glad you're doing all right. We'll see you
Thank you.
soon.